Hello everyone, welcome once again to our immigration podcast. I'm very happy to announce that today I have Riaz Anwar with me. Riaz, you're most welcome.
Thank you.
Well, since I have gotten hold of him finally, so I will be asking him some questions regarding sponsor license. So Riaz, let's get into it straight away. So who can apply for sponsor license?
Any business which is operating lawfully and they have acquired the registration approval from their regulator, if there is any regulatory body, and they have a robust HR system with the right key personnel, they can apply for a sponsor license.
Excellent. So how long does that application process take for anyone who wants to apply for a sponsor license?
Depending on which service they have opted for, if a business is applied for simply a standard service, they haven't used the priority. According to the Home Office, it takes about 8 weeks time, but in practice we have seen that it takes a lot longer, especially in cases where the Home Office has asked for further information. If the business has paid for the priority and provided that the priority has been accepted, it could take up to 10 working days.
Is there anything we can do to avoid further information requests when we make an application for a sponsor license?
So depending on how the business has obviously made an application and they've structured their documentation to support that they have the required systems in place, so which compels the Home Office to make a decision straight away. We have seen a couple of examples where the business has met the required finances, they have systems, but they have failed to produce the documentation which is required according to their business needs. So if the business provides correct documentation and structure them properly, so the application can be accepted without further information request.
Excellent. So my next question, follow-up question would be, what happens if application is refused?
So if a sponsor license application, there could be potentially two scenarios. If an application is refused, so there will be a cooling off period for the employer which they have to complete before they can apply. So the standard cooling off period is 6 months, after which they can make another application if they've been refused. But if an application has been rejected due to, let's say, they haven't provided the mandatory documentation, so they can obviously complete the documentation which is necessary again, and they can make an application straight away. They don't have to wait.
Okay. Right. Well, thank you very much. My next question would be with regards, if someone is granted sponsor license, what duties are they expecting? What type of management? What type of, let's say, what are they expecting from the sponsor license? How would they manage it?
So when a Home Office grants a sponsor license, that is due with a lot of obligations that sponsor has to meet. So one of which is that they have to keep reporting to the Home Office of any changes related to the employee and the business itself. So if any change take place regarding the employee's salary, their job commencement date, change of let's say their working pattern or change of their job duties, they have to report it usually within 10 working days to the Home Office through the SMS system. And if there is any change related to the organizational structure, the change of shareholding, let's say, or the change of business address, that has to be reported within 20 days again through the SMS system. This is highly important because we have seen a lot of businesses, they keep on changing addresses. I've recently encountered one similar situation with a client. They have changed multiple addresses. Now they are willing to sponsor another worker, and now they are struggling to find the previous addresses where they have they've got the tenancy agreement or their lease. So we highly recommend that if any change is taking place, they have to immediately inform.
Right. So basically what you're saying to your clients or anyone who wants to apply for a sponsor license is, once you are granted sponsor license, you want to make any changes, before you make changes, obtain legal advice.
That's absolutely correct, because a minor sometime mistake can lead to a very big problem. So obviously a business who has employed more workers, they could face more severe consequences of such changes, and so on their employees.
Could not reporting these changes result into revocation of their sponsor license?
That could potentially lead to revocation, but Home Office can temporarily suspend the license also, which restrict the employer to make any further sponsorships to potential workers they want to do, and subsequently they can also stop your further cost allocation request.
Right. Well, I also understand that Home Office can downgrade your sponsor license rating. Now it sounds like you're talking about school grading system, but it is what it is. So what's the difference between these ratings, and how many ratings are there for license?
So there are typically two ratings. One is sponsor license A rated or B rated. So A rated sponsors are those
so no C, D, E, F.
There is no C, D, F. They have only two ratings. One is if employer is obviously lawfully operating, they are meeting all the compliance duties, so they maintain their A license, A rating license. And then if employer breaches any of the conditions, but the Home Office suspend their license or they downgrade their license, in such a case they are granted B rating, in which they can only maintain their existing employees. They are not allowed to make further cost allocations, or they cannot even certify the maintenance of their existing workers if they are going for an extension. So B rating comes with obviously a lot of restrictions. So basically they have a license for only those who are already working for them.
And what happens if any skilled worker who is already working in that company, and company's license is downgraded to B, and the extension is coming, so their visa is expiring? What can they do in that situation?
If they have a B rating, you mean to say?
Yes. So sponsor has a B rating now. For some reason, it's been downgraded, and they have a sponsored worker whose extension is coming up. What will they do?
So for an existing worker, they can request a cost allocation. Okay. But for new workers, obviously there is a restriction. So any existing worker who they want to continue sponsoring, they can request a cost allocation.
Well, that's a bit of a relief. Yeah.
So obviously for workers who are already working for them, unless from the B rating they are further removed from the sponsor register and they've been revoked completely, obviously then they are left.
Then they can't. They'll have to find a new employer in that case. Okay. Well, another question, and I think that's probably the most common question we hear from small businesses mainly. I'm sure you will relate to that as well. Business owners, they often ask, I have a relative I want to sponsor, very good worker, I have a genuine vacancy for that person. Can I sponsor my own relative or my own self? For example, if they run a business, they obtain a sponsor license and they are a director of a company and shareholder, can they sponsor their own relative? And then extension of that question would be, can they sponsor themselves if they are migrant?
Yeah, we've heard a lot about the common buzz, which is self-sponsorship or self-funded skilled worker visa. So generally speaking, cost cannot be assigned by the owner itself to sponsor themselves. So they need to have another person, obviously, who can take the responsibility of becoming an authorizing officer, so that they can sponsor the other director, which is called self-sponsorship. So if I am on a post-study work visa, let's say I'm on a dependent visa of a skilled worker, any worker category which allows dependents, let's say. So if I want to do a self-funded or a self-sponsored skilled worker route, I need to find a suitable person who can act as a director, and I can then be sponsored by my own business. That's a general understanding, I would say, but there are a lot of cons when we go into reality of making an application. The other scenario is sponsoring a relative. So if I have a business and I am the director of my business, I cannot sponsor my brother. I cannot sponsor my cousins, relatives, uncles, aunts, because there's a very general guidance about sponsoring your relatives, and the Home Office generally places a restriction. But if in case they have a different authorizing officer who can assign the costs, but in that case the applicant has to declare that they are sponsoring someone who is related to the director.
Right. So even if they are not the authorizing officer, they are the director or the shareholder in the company, they still have to declare that their company is sponsoring the on.
Yeah, that is correct. Yeah,
It was someone related.
someone related to the management or the company owner.
Okay, well, that's an important information. Well, in terms of expenses, uh, how much is the fee for applying for a sponsor license? Standard, and if you want to apply for, let's say, extended service.
I think the fees have recently changed. As of I remember, it's £576 for the sponsor license standard application, and if you are making a priority application, that is an additional of £750, I guess. I don't remember exact figures, but this is somewhere close to the cost of it.
Right. Is there any other expense employer has to bear when they're sponsoring a skilled worker?
Yes, when the employer has got their sponsor license granted, for each migrant worker they want to sponsor, they have to pay a cost allocation fee and also immigration skills charge, which is for every 6 months the Home Office makes a calculation of skills charge according to the duration of the skilled worker's sponsorship tenure. So typically for a 3-year sponsor, it is coming up now nearly £2,000 if the employer is sponsoring for 3 years.
And that is separate from immigration health surcharge, because a lot of people confuse immigration skills charge, which employers have to pay, with immigration health surcharge, which employees have to pay.
These are two different costs completely, because health surcharge covers employees' health services with the NHS, and skills charges for the employers that they have to pay.
Gosh, it's expensive, isn't it? Employers have to pay a lot of fee, then employers have to pay a separate fee, then immigration fee, health surcharge. God, if someone has a family of 4, it's a lot of expense.
Yeah, they could end up paying maybe for a 5-year sponsorship we talk about, they could end up paying for a family of nearly £30,000.
Wow, why can't they start their own business with this money?
This is what it is. I mean, that's how they have designed the system, I would say.
Well, that's understandable. Next question would be, once you apply for a sponsor license and your application is pending, or once you are granted sponsor license and during the time frame you hold the sponsor license, can Home Office visit, or UK Visa and Immigration visit your premises unannounced?
This is what you commit with the Home Office as and when the Home Office would need access to your business premises, even through when you make the application. At very first stage, the Home Office can make a visit, but that is usually a planned visit. But after you've been granted a license, the Home Office can make even unannounced visit to check and monitor your duties as a sponsor license holder, whether you have complied with the record keeping, monitoring, and the general compliance, wider compliance of the employment laws. So they can make a visit to you.
A lot of inquiries come in where people have applied for a sponsor license, they have missed out something, or they don't have the relevant information. So that's one side of the story. Another side of the story is a lot of people get legal help to apply for sponsor license, and in both cases sometimes they're lacking and application is refused because they didn't know what they were doing. And on the other hand, someone else applies, a legal representative, a solicitor on their behalf, and Home Office comes back and says you could not have done that, you can't do it because you are not allowed, no one else is allowed to apply on your behalf. So how do you keep a balance in knowing what to do and at the same time getting some legal help on that as well?
Well, as a business you can take professional advice and they can help you structure your application, but since the Home Office has placed a restriction that the sponsor license application can be made by the business themselves, so they have to represent themselves. As a representative, as a legal representative, I would say no one is allowed to make an application on behalf of the business. However, they can take help and they can structure their application according to the changing needs of the sponsor and wider immigration laws. I've seen one client today. They have a very reasonable turnover. They made the application which got rejected within few days because they failed to produce the documentation the required 4 documents according to the Appendix A. But they had those documents with them, but they didn't knew that they have to submit within 5 working days. Right. So they made the application, paid the fees, and they were of the view that now Home Office will ask and then we will send them, and they were not aware, so the application simply got rejected.
So if they had taken legal help, they would have known that they have to provide those documents. Would have saved them a lot of hassle.
Yeah, absolutely, because that also becomes a negative point for your future application, that maybe you were not aware or you don't have a system in place. That's why you've made an application which got rejected. So the Home Office can do further strict process of your application.
Well, Riaz, we have gone through what happens or how to obtain a sponsor license and issues that are attached with it. Now my next question would be, what happens once this license is revoked?
So if for some reason Home Office has revoked the license, typically we have seen the reasons are that the employees have not reported the required changes in the SMS system, or they have underpaid sometimes. If they have not met the regulatory requirements, obviously challenging revoked license is going to be difficult. But if there are concerns which can be addressed, so the remedy is to challenge it through the judicial review process. So the first step is to send a letter before action to the Home Office, reasoning them with your answers which they have, or the reasons for refusal. So you can challenge them, you send a letter to them and give them the timeline in which the Home Office should revert back and provide you with maybe an maybe they can either upheld their decision, or they can withdraw their decision and they can give you the status back. Or if they maintain their decision, then you can go for a judicial review. So that's the only remedy, unfortunately, in the sponsor license application employer has.
Right. Well, that's very sad, because going through all that effort, and if you have employees, for example, you were mentioning the other case where there's a care home who has almost 2 dozens of employees, skilled worker employees, and license is now revoked. And the only remedy they have is judicial review, which takes some time, and it's not a fact-finding remedy either. It's a very limited remedy.
Very limited, yeah.
In that case, businesses will suffer. But again, if that's the remedy we have under the law, that's the remedy we have.
Yeah, exactly. Because this is what the Home Office expect when they, place this responsibility on you, that you use the facility of sponsoring a foreign migrant worker, that you maintain your compliance. It's really important, because when a sponsor license has been granted, we have seen small businesses especially, they don't pay attention. They just keep on doing business, or maybe just keep sponsoring. But when it comes to compliance check, if the Home Office comes back or they make a further allocation request, sometimes they usually don't have any record for what the changes have been done in the business, or the record they have kept for the employees. So this is highly important to maintain the compliance, and I would recommend every business to get help from a legal representative, so that they can check or test their compliance. They can have their file reviewed or their system reviewed by a competent immigration lawyer, so that they remain compliant and they obviously maintain their rating for the license.
And it's almost a one-off thing. So once you know what needs to be done and you have that system in place, all you have to do is that implement that system.
Exactly. I mean, once you develop a system, obviously many companies, including us, we can help structuring a system which can last for longer, and we can keep you updated of any upcoming changes in the compliance related issues. So if a business maintains it, obviously they retain their license.
Excellent. Well, thank you very much, Riaz, for your time. And for our audience, if you have any questions regarding sponsor license, you know where to go. If you have any compliance issues, you know who to ask. Thank you very much for your time, and do not forget to ask questions if you have any in your mind. Thank you very much.
Thank you.